I can answer. The matter that's before the court currently, the first one is the cancellation. As of yesterday, the 30th of May, I think if DROAC is present, or CapeValley are also cited, the matter has been set down, and so the matter will be heard. So at any given junction, probably before the end of this term, the matter will set down and we should have an answer in terms of the cancellation of the actual development contract. The other issue that's before the courts was the issue of ownership of the property and ownership in terms of the whole entire property, which is not just lot 34, but inclusive of lot 1 up to 34. The development that we're talking about is actually lot 34, where the courts had previously referred the matter to arbitration, and arbitration resolved that all of the 5 Chiluku siblings are equal shareholders. The last process is actually the registration of the arbitral award. So in terms of ownership of the land, unless if the developer can show us proof of their ownership, it would have been helpful if the developer had actually produced the development contract. The development contract spells out very clearly in terms of what they were entitled to pending delivery. They are misleading the Honorable Minister, I think, and all those in attendance, that the project is complete. Phase 1 ought to have been completed by 2020. We're in 2024. Phase 1 is less than 50% complete. The project was supposed to be done in consecutive phases. Phase 2 was supposed to be completed in July 2022. It's still incomplete. Phase 3 was supposed to be completed by 2023. Last phase, phase 4, was supposed to be completed by phase 2020. Phase 4 was supposed to be completed by 2024. In the development contract, it spells out very clearly that the developer was not supposed to sell any or to deal with the land until 3 conditions had been set. First, that the project was complete. Secondly, that a compliance certificate had been issued. And thirdly, that their lawyer, who had been given special power of attorney, had transferred the property out of the landowner's name into their name, where they're only supposed to deal with the land. As it stands before you, Minister, there are buyers who claim that they bought. There is no mandate that the developers or the landowners, that the landowners ever gave to CapeValley in terms of the sale. The contract, I think, it spells out clearly. The contractor is misleading, I think, the audience. They came and stated that they had funding to do the project. Hence, those clauses were put in place, so that there will be no sale, will not have the issues that we're currently having in this particular meeting, where there are third parties that are coming through claiming ownership or claiming any entitlement to the property. So as it stands, the issue of ownership is also before the courts, as well as the cancellation of the development contract. It's also before the courts. Ownership as well.
The permit, the issue is the permit. We could not issue the permit because the permit is linked to issues to do with ownership, which are issues are at the court. So our legal team or council lawyers advised that we cannot deal with the permit when this issue is still with the court. We can only do that when the issue are resolved at the court, then the permit is issued. Because normally the permit is issued in the name of the owner or the title holder or the deed holder. So the permit, what is holding the permit is the dispute, which is at the court.
Chair, I think, like the Penseke said, that we need to find out from the legal whether we are not encroaching into the merits of the matters that are at court. Because everything that my brother here, he now admits that it's my brother, it's not my father. Everything that he's saying, he had enough opportunity to present that before the court. He didn't. He comes into this court and he starts creating all these little stories that he's creating. You can all tell that it's not linking up, it's not cohesive. There's no fluidity of thought in what he's saying. The fact that he saw my name that I had gone in there, he's trying to imply that I put some papers down. That's where he's trying to get it. And it's false. And that is false. So May we please just bear in mind that we are handicapped. We are handicapped in the sense that we cannot answer or we cannot speak to some of the things that are being said here because these matters are before the court. We cannot, and I repeat that, we cannot participate in this kind of discussions as long as it's before the court. Let's allow the court process to go on. There's a lot of things that my daughter Prim, you can refuse to be daughter, but you are my daughter.
So don't refuse
She is not refusing. Let me tell you, she is not refusing because she knows how we did back with his father.
Okay.
And she knows how we did back with her and her
I
husband.
guess you guys are brothers, right?
We brothers.
In the elder brother normally customarily is
That's why that law was removed.
you know what?
It's troublesome. That law is
To save
troublesome.
time, to save time, petitioners, I think if you had the advice we got from our legal person who is here, Mrs. Chuma, and the proposals coming from the brother. This matter is before the courts. And our attempt to want to be discussing these things is a violation of the statutes that are there. If matters are before the courts, the executive does not interfere. And we are seated here as the executive. So given that, we may have to adjourn this meeting and wait for the courts to make a ruling, then we'll move forward. Do you have something that is different from what we said?
I won't be preempting into matters before the court, but maybe to clarify on matters that have already been finalized by the courts.
Okay.
So the Supreme Court said, but it did not decide on the issue of ownership. Parties were referred back to arbitration. Arbitration, they've been awarded an award that they are 50%, they have an understanding in terms of the memorandum of agreement. What I want to state on their memorandum of agreement is that in terms of the memorandum of agreement that they have had registered with the arbitration, that they have an award with the arbitration, they acknowledge that there are stands that have been sold to the developer. So if we cannot enjoy any other rights, at least let us enjoy rights that they have given us in terms of their family memorandum of agreement. They've already acknowledged that there is a share for the developers. Maybe for the avoidance of doubt, I can read the part that says that they've acknowledged.
Can I come in before she?
You
reads
can
that.
give me a chance.
No, we are asking the
Boundaries
chair.
are clear.
We are asking the chair.
Chair, if you, okay.
So this clause says, whereas the title holders in fulfillment of the promise to share the farm with their siblings hereby avail the stands after paying the developer for sharing with other beneficiaries in equal shares. And then they also state clause 2, now therefore it is recorded, subdivision of Swallowfield. In terms of a subdivision permit issued by Northern Town Council, of the 1,520 stands produced, and taking into account stands used as payment to the developer and the endowment to Northern Town Council, the remainder of the stands are shared equally among the 5 parties. So I believe we should be allowed to enjoy what they have given us in terms of their memorandum of agreement and the arbitral awards that they've got.
Can I come in? Can I come into a point? You have referred to stands that are in the agreement that was cancelled, am I correct? And that
that agreement hasn't been cancelled.
No.
Okay. Let me rephrase. We're referring to the agreement that's before the court. Am I correct? No, we are talking about the cancellation agreement, HH 7709 of 23.
The development agreement,
Yes.
it hasn't been cancelled.
No. We're saying it's before the court.
Hello. I want to believe that you are representing him.
No.
Represented.
He's representing the one that's not here.
He's been the one that's not here.
Yes.
Do we have anything to show that he's representing the one that? Because we don't know him.
Well, do you want us to call him?
Yes.
No, we don't want to go to that.
We can call it.
We are
We can-
adjourning
we
the
can-
meeting.
Can you call it?
We are adjourning the meeting now because we can't separate these issues. They are interlinked.
Okay.
The matters before the courts.
Yes.
I think for the comfort of everybody, let's adjourn this meeting.
It's fine.